Hello, everyone, and welcome to Uncivil Law, and I hope you're having a great day. As always, I'm your host, Kurt Mueller, a licensed attorney in Texas, Virginia, and before the U.S. Supreme Court, and I hope you're having a great day. For today's story, we turn our attention to the state of California, which is dealing with the issue of compelled speech as it relates to certain nursing environments. The state of California would like to force certain workers to use the pronouns of patients, despite any objections by the nurses or medical staff. And the Supreme Court of California has determined that this is totally cool, and we can force people to use speech they don't want, even with a criminal penalty involved. So if you don't do the speech they want, if you don't use the preferred words and the preferred pronouns, you can go to jail in California. The Supreme Court of California apparently is okay with this. So we're going to read this decision and try to understand it better. We are in the Supreme Court of California in the case of taking offense versus State of California, which that case name alone is kind of worth the price of admission. But I digress. And we're going to read this and see what it has to stand for, the legal propositions it has. We are in an opinion by the Chief Justice of the State of California. In 2017, the legislature of California, in its infinite wisdom, enacted the Lesbian, Gay, Bisexual, and Transgender Long-Term Care Facility Residents Bill of Rights. The legislation comprehensively addresses issues concerning lesbian, gay, bisexual, and transgender seniors' access to and treatment by long-term care facilities, an umbrella term covering entities that provide services ranging from skilled nursing to residential personal care for the elderly. Only one particular aspect of the enactment is at issue at this time. The Health and Safety Code, Section 1439.51, Subdivision A5, prohibits staff at a long-term care facility from willfully and repeatedly failing to use a resident's preferred name or pronouns after being clearly informed of the preferred name or pronouns when they do so wholly or partially on the basis of a person's actual or perceived sexual orientation, gender identity, gender expression, or HIV status. I'm not sure how HIV status relates to pronouns, but I'm sure someone will inform me at some point. And the Supreme Court of California, wanting to be sufficiently woke, notes that it uses the term LGBT in referring to persons protected because that's the term the legislature used. So don't think that it's because they're not being overly inclusive. It's just what the legislature chose, so they're going to use the same nomenclature. Okay. Let's see where we were. Great. Before the pronouns provision went into effect, taking offense, the plaintiff, which describes itself as an entity dedicated to opposing efforts to coerce society to accepting that transgender fiction, that a person can be whatever sex gender he or she thinks or chooses to be, which is kind of my view. I have the view that a biological man is not a woman and a biological woman is not a man. And that's just a definitional issue for me. I do not believe that as a categorical rule. In the nature of a category, what things belong in the category versus what things do not belong in the category. And some people say this is transphobia, and I just don't agree with that characterization. I just don't think that you can just claim something and then say it's a phobia if I disagree with it. I just don't think that as a matter of categorization, a biological male can be a woman. And I don't think a biological woman can be a man. That's what I think. That's what I believe those terms mean. And I don't know what to tell people beyond that. But I mean, and that's what I think, and that's what this group taking offense thinks. They tend to agree. And they also agree that we shouldn't be able to coerce people into believing or saying the opposite. I have freedom of speech. You have freedom of speech. Freedom of speech is great for us all. I have the right to believe things. I don't have the right to state those beliefs. You have the right to believe different things. You have the right to just look down on me for my beliefs. You have the right to judge me for my beliefs. I don't have the right to judge you for your beliefs. That's how we roll. but you can't compel me to say the words. That is not one of the things that you get to do. So not so much with that. In any event, they filed a petition for writ in the court seeking to block enforcement of the pronoun provision as facially unconstitutional, which kind of seems facially unconstitutional to me. After trial, court denied the petition. The Court of Appeals reversed, holding that because the challenge provision violates the First Amendment, it is insufficiently tailored to address the state interest in eliminating discrimination. It's unconstitutional, said the Court of Appeals. The Supreme Court of California has additional thoughts. In this court, the defendant, State of California, asserts for the first time that plaintiff lacks capacity to sue state officers or entities under tax-paying standing doctrine articulated in the Civil Code of Procedure. Okay, so that's going to be an issue primarily under state law. Under federal law, you can't sue just because you're a taxpayer unless it deals with religious discrimination, and then you can. So that's an exception to the rule. But typically speaking, you don't have standing just because you pay taxes and the government is doing something you don't want. It has to harm you in some way beyond the fact that you pay taxes. Everyone pays taxes. That's not considered a harm to you, at least relative to anything that the government is doing in general. Now, again, if they're doing it to you, then you have all the standing in the world, right? If the government is trying to do something to you in specific, then, you can sue them all day long, no problem. But you can't sue them because they're doing things in the ether that have nothing to do with you unless it's religious. Unless it's religious. They're trying to do something in a religious domain, then you can. That's a matter of the federal law, though. Of course, the state law might have its own issue on that, but that's what they're talking about. Okay, so in any event, the state of California thinks these people might not have standing to sue as a matter of state law. As explained below, we agree that the present version of the section as amended does not allow standing to sue wholly state officers or entities. And yet, under the unusual circumstances of this case, as we've done in an analogous setting, we also conclude that our interpretation of the statute does not impair our jurisdiction to rule in the merits. That doesn't make any sense legally. I don't understand that. That makes no sense. These people don't have standing, yet we're still going to rule on the issue anyway. How is that a thing? I don't know. They don't have standing, but we just really want to rule on it anyway, so we're going to. Yeah, no federal court would ever do this. But the state of California wants to, I guess. All right, that's fine. On the merits, the state asserts that the pronouns provision survives plaintiff's challenge under the First Amendment. In addressing the question, we emphasize the narrow context in which the challenge statute operates. It's narrow for the moment, but of course it never ends that way, right? The legislature passed a law dealing with long-term care facilities with the elderly. But now that they have this wonderful new power, do you think that the only time they could do this is in elderly care facilities, long-term care facilities with medical practitioners? Like, what is the principle that would limit the legislature to that domain? And the answer is there is none. So the Supreme Court's like, this is a super narrow context for the moment, but why can't the legislature pass this with respect to schools and school teachers? Why can't they pass it with respect to businesses in general? Why can't they expand beyond in the future? What is the limiting principle? There really isn't one. So it's super duper narrow just for this one time, don't you know? Don't worry about it being expanded. This won't be expanded. Sure it won't. Yeah, that's definitely how that's going to work. It seeks to protect long-term care residents' right to be free from discrimination in a setting which they constitute a captive audience, which has in fact become their home. The provision regulates conduct by staff persons whose job it is to provide and support medical treatment and intimate personal care, thereby seeking to promote an environment conducive to such treatment and care. It is carefully calibrated and does not restrict long-term care facility staff from expressing their views about gender to anyone, including a resident, in an otherwise lawful manner, other than by misgendering a resident, And even then, prohibition is limited to willful, repeated, knowing acts done because of the legally protected characteristic. The Supreme Court of California is trying to make this super narrow, but it's just not. You know it's not, and I know it's not. This is just long-term care facilities. This is because it's their home. This is just in these limited domains, don't you know? Do you think it ends that way? Does it ever end that way? Not a chance. So, the legislature's already drafting new ideas, I'm sure. In light of the unique setting and scope, we conclude the provision should be analyzed and upheld as a regulation discriminatory conduct that incidentally affects speech. So they want to say it's conduct that only has incidental impact on speech, even though it's literally the words they're saying. So it's incidentally speech, even though it's directly don't use these words. I'm not sure how that's incidental, but the California thinks it's incidental. I don't agree, but that's what they seem to think. It should not be subject to First Amendment scrutiny as an abridgment of freedom of speech. And even assuming the statute were subject to intermediate scrutiny, which I'm not sure why intermediate scrutiny is the relevant test here. Why not strict scrutiny? Why wouldn't strict scrutiny be the right test as opposed to intermediate scrutiny? Because it's a time, place, manner restriction? Only these times and these places? I don't know, man. I don't know. It feels a lot like subject matter to me. I'm not sure intermediate scrutiny is the right play, but all right. We find the provision easily satisfies this test. Finally, we conclude the possibility of enforcement by way of a pre-existing criminal penalty for particularly egregious violations of the statute does not render the challenged provisions facially unconstitutional. Accordingly, we reversed. All right. Various long existing laws prohibit discrimination, including discrimination on the basis of gender identity and gender expression in public accommodation. For example, a different law bars all business establishments of every kind from discriminating on the basis of sexual orientation or gender identity. Well, to the extent it doesn't involve words, that's a completely different issue, right? If you're just a bar serving drinks and someone comes in and wants a drink, serving them the drink is not speech. It's service. It's here's your drink, right? There doesn't necessarily have to be any words involved in this at all. You could theoretically have a transaction at a bar that doesn't involve any words. Someone just points to the sign, or points to the thing, and you give it to them and they pay you. Words are not necessarily required in this transaction. And to the extent that words are involved, it's completely incidental to the service because you don't need the words. So, there's that. The California Fair Employment and Housing Act prohibits the owner of any housing accommodation from engaging in discrimination or harassment on the basis of gender, gender identity, gender expression, or sexual orientation. And bars, as enacted as part of the Residents' Bill of Rights, this bars residential care facilities for the elderly from discriminating against a resident based on perceived identity. Well, to the extent they're providing medical services or care services, then, fine. I think I want to turn down my microphone just a touch. My microphone's already pretty far down, actually. Let's just drop it like one step and see if that does anything for us. All right, let's give that a shot. Enacting the LGBT Long-Term Care Resident Bill of Rights in 2017, the legislature asserted that although these related existing laws already prohibit discrimination, their promise had not been realized in long-term care. The legislature sought to accelerate the process of freeing LGBT residents and patients from discrimination, both by specifically specifying prohibited discriminatory acts in long-term care and providing additional information and remedies to ensure that LGBT residents knew their rights and means to vindicate them. In support of this enactment, the legislature articulated various findings. It cited its own prior conclusions expressed a decade earlier concerning the challenges faced by LGBT seniors who need access to long-term care facilities, yet because of lifelong experiences of marginalization, avoid accessing elderly programs and services, even where health, safety, and security depend on it. I would think of all states, finding LGBT-friendly long-term care facilities in California would not be especially challenging. It might be challenging in some jurisdictions, but if you're concerned about LGBT discrimination, I wouldn't think that you'd have to go necessarily totally out of your way to find a long-term facility that will placate you and your beliefs. So they're saying there's a bunch of seniors who won't seek care because of LGBT. In California, they won't seek care? Really? Okay. I mean, if you say so, I mean, all right. The legislature found that such seniors often must rely on others for necessary care and services and may no longer enjoy the privacy of having their own home or even their own room. Okay. Moreover, the legislature found a 2013 study of LGBT seniors in San Francisco disclosed that nearly 60% lived alone. Many reported poor physical and mental health as compared to seniors in San Francisco generally. LGBT seniors had high need for care, but often lacked family support networks available to non-LGBT seniors. Well, the fact that they don't have family is sad and all, but I'm not sure what we're supposed to do about that. Further, LGBT seniors' fear of accessing services is justified. In San Francisco, it's justified? Seriously? Nearly one half of participants report experiencing discrimination in the prior 12 months because of sexual orientation and gender identity. In San Francisco. Seriously. Okay. The legislature cited a 2011 study relating that 43% of respondents reported personally witnessing or experiencing instances of mistreatment of LGBT seniors in long-term care facilities, including all the following: being refused admission or readmission, being abruptly discharged, verbal or physical harassment from staff, staff refusal to accept medical power of attorney from a resident spouse or partner, discriminatory restrictions on visitation, and staff's refusal to refer to transgender resident by his or her preferred name or pronoun. The legislature comprehensively addressed each of the above italicized problems by adopting the health care code, making it unlawful for a long-term care facility or facility staff to take various actions, wholly or partially based on a person's actual or perceived sexual orientation, gender identity, gender expression, or HIV status. Okay. The legislature listed the unlawful conduct: denying admission to a long-term care facility, transferring or refusing to transfer a resident within a facility or to another facility, or discharging or evicting the resident from a facility, denying a resident's request to share a room. Where rooms are assigned by gender, assigning, reassigning, or refusing to assign a room to a transgender resident other than in accordance with a transgender resident's gender identity unless the transgender person requests. So apparently that means that if the transgender person considers themselves a woman, they want a roommate, the other person can't object. The other person can't object to it, like, I don't recognize this as a woman. I don't want to share my room with a man. And apparently, no, the other resident, if I understand that correctly, is required to accept this. So they don't get any rights, I guess. Or not enough rights, at least in this situation. So there's that. Prohibiting residents from using or harassing a resident who seeks to use or does use a restroom available to other persons of the same gender identity, regardless of whether the resident is making a gender transition or appears to be gender non-conforming. So again, we can't have the other residents saying anything mean to their fellow residents in this facility. Harassment includes, but is not limited to, requiring a resident to show identity documents in order to gain entrance to a restroom available to other persons of the same gender identity. Willfully and repeatedly failing to use a resident's preferred name or pronoun after being clearly informed of preferred name and pronouns. I'm not Oh, you can't see the text anymore. Sorry. I'm not getting the urge to, go visit California right now. Denying a resident the right to wear or be dressed in clothing, accessories, or cosmetics that are permitted for any other resident. The enactment adopted two additional substantive requirements. The law requires long-term care facilities to maintain records of residents' gender identity, correct name as indicated by the resident, and pronoun of each resident as indicated by the resident. If they are someone who floats between pronouns or names, I'm not sure how that's supposed to work. That's not specified. The relevant law concerns medical information privacy. Another law governs resident autonomy when unclothed. The LGBT Long-Term Care Bill of Rights did not establish a new enforcement mechanism. Instead, it enacted the Health and Safety Code, which incorporates pre-existing enforcement procedures. As explained, by virtue of the section, licensed entities and their staff who violate any enactments, including by allowing other residents to say the mean words, including the challenged pronoun provision, are subject to the same administrative and civil, and in egregious cases, criminal penalties applicable to violations of a myriad of other duties imposed on the staff. The plaintiff describes itself as an unincorporated association. They filed a writ of mandamus. There was some trial. We can skip the proceedings in the trial court for the moment. We can skip the proceedings in the Court of Appeal. Let's move on to standing for a moment. The state asserts plaintiffs lack standing. Although the state did not raise the standing issue until its petition for review in this court, contentions-based lack of standing involving jurisdictional challenges may be raised at any time. Yeah, I mean, that's true in the federal law too. Sometimes standing is raised, by the U.S. Supreme Court. I've seen it even once, sua sponte, where the Supreme Court once themselves raised it for the first time and then dismissed a case for lack of standing. So everything disappeared from the beginning because there was never standing at all. So 10 years of law just evaporated, right? Because the Supreme Court said, there was never standing, so all this law goes away. That can happen. Yeah, it's an issue. It's an issue of subject matter jurisdiction. Yeah. The state argues because the plaintiffs lack taxpayer standing, because the statute only applies to suits against local government. Here are plaintiffs sue only the state government. State further contends the law occupies a field, and the common law taxpayer standing doctrine, under which suits against state officers have been allowed, is ceased to exist. Plaintiff, which has the burden of standing, contends it has standing because despite the provisions limiting words speaking of suing only local entities, this court has judicially broadened the statute to allow suits against the state and officers and other entities. Plaintiff further argues common law taxpayer standing continues to exist and is satisfied here. As explained below, we agree with the state that section whatever does not afford standing to sue the state or its officers or entities such as those in this case. But under particular circumstances of this case, our interpretation does not impair the ability to address the Court of Appeals. Well, it should. If this were the U.S. Supreme Court writing this, they would never write this. If the U.S. Supreme Court determined that there was never standing, they wouldn't say, but we're going to still hear it anyway, because the Supreme Court doesn't do advisory opinions. The Supreme Court would say, okay, there's no standing here, and there never was standing. And so the whole case disappears. The Court of Appeals decision disappears. The district court decision disappears. It all vanishes because it was all legally infirm from the beginning, ab initio, as the lawyers like to say. But here, the California Supreme Court is apparently not going to let standing be a problem. Apparently, the California Supreme Court is like, well, they don't have standing, but we really want to rule on the merits anyway. So we're going to decide the merits even though there's no one here right now. There's no one standing in front of us because there's no standing, remember? So there's no one standing in front of us, but we're going to rule on the issue anyway because reasons. This is a bizarre way to run a tea shop. I'm not feeling it. Hold on one second. Sean says hi from Potentially Criminal. Sean says hello. Let's see, where were we? In view of this determination, we need not resolve the parties' dispute concerning whether doctrine and common law tax. Sorry, by the way, for taking the call. I took the call on the chance that potentially it might relate to Nate because, as we all know, Nate has been recovering from surgery. He didn't wind up being readmitted to the hospital after all, by the way. I had conflicting information from Nate, by the way, but he hasn't been readmitted to the hospital and things are going relatively well. The short-term recovery still looks good for anyone who's following the story. The medium to long term is still a bit of a question mark. There's questions as to things, and until pathology comes back, which I don't believe is due until tomorrow, they're not going to know things about medium to long term, but the short term is good. So that's plus. So we're all happy about that. That's good news. Let's go back to this case. But under the particular circumstance of this case, our interpretation of law does not impair our ability to address the merits. In view of the determination, we need not resolve the parties' dispute concerning whether doctrine of common law taxpayer standing continues to exist. As explained below, we encourage the legislature to comprehensively review the law and existing common law authority in order to harmonize and clarify circumstances on which the state may be sued. Why does it matter? Why does the legislature need to clarify anything when you yourself are just going to allow the lawsuit to continue anyway, man? Beginning in the late 19th century, okay, they're going to talk about taxpayer standing. We don't have to discuss this right now because it doesn't matter. It doesn't even matter to them, right? Because they're going to discuss taxpayer standing for a while, but they've already determined that they're not going to resolve the issue. So but now we're going to discuss it for a while for some reason. So okay, they're going to discuss taxpayer standing for a while for some reason, even though they themselves decided. Then they're going to discuss common law, even though they decide it doesn't matter. So they're going to still talk about it anyway. Now there's a section dealing with, they're still talking about standing for some reason, having determined it doesn't matter, but they're still talking about it, and they're still talking about it. This is hilarious to me. Then they're talking about an amendment relating to standing, blah, 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 blah. They're still talking about it. Okay. All right. We exercise our discretion to address the Court of Appeals analysis and judgment. Based on the contention the plaintiff lacks standing, the state urges us to vacate. That's what you would normally do, without reviewing the merits of the court's conclusion the provision is unconstitutional. As we observe, standing is jurisdictional. What the fuck? Standing is jurisdictional and must exist at all times until judgment is entered. Yet, in light of the highly unusual posture and circumstance of the case, were we to conclude we lack jurisdiction to address the Court of Appeals analysis and judgment, invalidating the challenge provisions for assertedly restricting more speech than necessary to achieve the state's compelling interest, a cloud over the Constitution of the statute, a significant matter of public interest would continue to loom. This is very, very bizarre. I'm not actually sure which is more bizarre at this point, the underlying merits decision or this, I guess we'll call it jurisdictional decision. They just said just now, remember? They just said this is required and must be true for jurisdiction. Yet were we to actually conclude that, we wouldn't have, there might be a shadow over the constitutionality. But if you need it, you need it, right? So it's like, but they're going to ignore it so they can rule on it anyway. Why? This is bizarre, man. Bees and fish together, bizarre. I don't know if it's, you have to be a lawyer to understand how messed up this is. I'd like to think I'm explaining it, but it's pretty fucked up. What's happening right now? It's pretty fucked up. Such determination, unaccompanied by any ruling on the merits, by this court explaining why the court below erred when announcing its reason for invalidating the provision, would impair the administration of justice, leaving the state uncertain whether it's free to enforce the statute, and those who view the statute as unconstitutional but wish to engage in the conduct that violates it would be uncertain whether they're free to do so. In light of these extraordinary circumstances, and mindful of our own prior decisions interpreting the predecessor statute to afford standing, and also a view of the parties to thoroughly litigate the merits, we exercise discretion, proceed to the merits as addressed in the judgment, even though there's not standing. Nevertheless, we determined it appropriate to address petitioners' sentencing arguments for guidance in lower courts and exercise discretion to do so. Having so concluded, we do not address where a plaintiff has a public interest standing, or where the common law taxpayer standing continues to exist, and where, if it does, such standing is satisfied. So we're not going to answer that, even though it is essential. It is an essential thing. It must exist. Remember, they said that. It must exist. But, In the meantime, the legislature, perhaps working with the Law Review Commission, is encouraged to survey the field. How's the microphone sounding, by the way? Is the background noise less than it was before? Echo less? Is there less like... I turned down the microphone a step. Do I need to turn it down another step so there's less pickup of mouth noises and stuff? How are we doing on audio? Should I drop the microphone gain another level? Is it picking up too much stuff? It was great before, but it's picture perfect now? Excellent. Very good. All right. Plaintiff challenges the pronouns provision on the face under the First Amendment, which prohibits laws abridging freedom of speech. I would think. Presumption of constitutionality and why facial challenges are disfavored. They're generally disfavored, but freedom of speech issues less so. As the Court of Appeals recognized and our prior cases have held, there's a strong presumption that act of the legislature is constitutional. That's true. That's true in the federal law too. Mere doubt by the judicial branch as the validity of statute will not afford sufficient reason for declaration of invalidity. Instead, the statutes must be upheld as constitutional unless invalidity clearly, positively, and unmistakably appears. These principles govern a challenge to the facial validity of a statute. A corollary principle is relevant here. As a general matter, facial challenges are disfavored for several reasons. They often rest on speculation, although not so much here, and raise the risk of premature interpretation of statutes on the basis of factually bare bones records. Facial challenges also run contrary to fundamental principles of judicial restraint that courts should neither anticipate a question of constitutional law in advance of the necessity of deciding it, nor formulate a rule of constitutional law broader than is required by the precise facts to which it's applied. Finally, facial challenges threaten to short-circuit the democratic process by preventing laws embodying the will of the people from being implemented in a manner consistent with the Constitution. We must keep in mind a ruling of unconstitutionality frustrates the intent of the elected representatives of the people. We evaluate the merits of a facial challenge by considering only the text of the measure itself and not application to any circumstances of an individual. True enough, I mean, that is a facial challenge. Under a facial challenge, you don't worry about the specific facts at play. You worry about basically whether or not there's any lawful application of it. Is it lawful under any interpretation? If it's lawful under any interpretation, it will survive a facial challenge. It may not survive an as-applied challenge when you get particular people involved, but as long as it has basically any lawful use, then it's fine facially. That's true. A litigant mounting a facial challenge bears the formal burden to demonstrate invalidity, at least the general or vast majority of cases. And if you're in the federal law, that's basically like essentially all. So if you're federal law, you're like essentially all. You know, there might be some very narrow legality of it, but yeah, you basically have to show it's invalid under almost every application. This isn't an exacting standard, not as exacting as the federal standard. Explained below, the plaintiff has not carried this burden. In reaching the contrary conclusion, the Court of Appeals relied on Reed versus Town of Gilbert, in which the Supreme Court of the United States, they call it the High Court. which seems slightly diminishing as opposed to Supreme Court, High Court. I don't know. Maybe it's just me. Consider a municipality's regulation that treat different fashions, various categories of outdoor signs based on the type of information sign conveyed. Yeah, I remember this case. It was, I didn't really like that decision, to be honest. The law subjected temporary signs directing the public to a meeting more stringent restrictions than other sign messages. A religious group that lacked a permanent location wished to post signs showing its Sunday services and locations challenged the regulation's content base. The trial court rejected the challenge, and the appellate court affirmed, finding the law content neutral and upholding it. The High Court, otherwise known as the Supreme Court of the United States, reversed. The court found the town signs law to be content based on its face. The court held that such laws which target speech based on cumulative conduct are presumptively unconstitutional and may be justified only if they survive strict scrutiny analysis. That is, the government proves they are narrowly tailored to serve compelling state interest. The Court of Appeal below concluded that Reed required it to apply strict scrutiny to the case. The state disagrees. It argues that despite the High Court's language in Reed, a standard review less exacting than strict scrutiny, a form of intermediate scrutiny, analogous to time, place, and manner, is appropriate when, as here, the statute shields an unwilling and captive audience from verbal discrimination. I don't know about that. $10 from World Radio 332. Thank you for the super chat. So what happens if a lawyer uses a descriptor to paint someone a certain way in court, which is accurate, not obscene, yet now deemed not appropriate under California mandating the use of preferred pronouns? Yeah, they were trying to do this as a matter of ethics. It was a proposal by the ABA for this, and it was even broader than that. I want to say it was like 8.4D or 8.4G, something like that. It wasn't adopted, I think it was adopted by like one or two states. I think it got maybe adopted by Pennsylvania, and then it got struck down by the courts anyway. But they were trying to do this. They were trying to make it so that it was unethical for lawyers to, in their speech and comments, discriminate by, saying the mean words. And it's blatantly unconstitutional, as was determined by the federal appellate court in Pennsylvania, because Pennsylvania, I think, adopted it, and then someone sued the bar, and like, yeah, you can't do that, bar. You can't make that unconstitutional. And yeah, what happens if they try to do this as it relates to courtroom stuff? Yeah, this is a good question. I'd say it's unconstitutional, but then again, they're saying in this context it's constitutional. So if they tried it for lawyers in court, it's like, I don't know. I mean, it should be unconstitutional. It should be unconstitutional here. But that's where we're at. Thank you for the super chat. Somewhat similarly, amici curiae from California professors of freedom of expression and equality law also argue that strict scrutiny is inapplicable here. They observe that Reed concerns speech occurring in a traditional public forum, where information implicating the marketplace of ideas is most strongly protected. Distinguishing from such a setting from the present one, the professors urge the Reed holding does not extend to all contexts in which words are voiced, to courts and care facilities no less than streets and sidewalks. They assert the challenge pronouns provision does not regulate public discourse, but only verbal conduct outside the marketplace of ideas in a place at one's workplace, a public accommodation, a medical care facility, a place of residence where LGBT seniors are uniquely captive. If they argue, even if the statute is viewed as reaching a mix of protected speech and unprotected speech, strict scrutiny would still be the wrong framework to apply. Instead, an overbreadth analysis would then be required. An overbreadth analysis under what standard of review, though? Finally, and relatedly, amici curiae, Lambda Legal Defense and Education Fund, National Center for Lesbian Rights, ACLU of Southern California, urges to view the challenge statute not as content-based or protected speech, but instead of regulating discriminatory conduct. But this isn't conduct. This is speech. This is literally words. It's literally the words. Other things in there might have been conduct, using a bathroom or not, dressing or not, maybe. But these are literally words. This is speech, man. This is speech through and through. Thank you for the 128 of you currently watching. I do appreciate it. If you wouldn't mind hitting the like button, it does help with the algorithm. And don't forget to subscribe along the way. It helps the channel grow. At oral argument, the state endorsed a version of this approach. As explained below, we conclude that an analysis akin to that last described, one that evaluates restrictions on discriminatory conduct, is appropriate in this setting, and challenge provisions should be upheld under that approach. Finally, as explained below, we conclude that the circumstances enforcement may, in some rare and extreme circumstances, how rare and how extreme one wonders, right, possibly trigger potential criminal penalties, does not call for invalidation of the challenge pronouns. I need a drink of water, so please excuse me one moment while I go get a drink of water. I will be right back. Okay, we're back. Where were we? The relevant law constitutionally prohibits discriminatory conduct in long-term care facilities. As observed earlier, the Court of Appeals agreed with plaintiff that pursuant to High Court's decision in Reed, the Health and Safety Code is subject to strict scrutiny analysis under First Amendment and fails. We conclude that Reed and First Amendment strict scrutiny analysis does not apply. The challenge statute addresses and operates a narrow setting. It properly regulates discriminatory conduct aimed at vulnerable seniors who typically constitute a captive audience residing in long-term care facilities that become, in effect, their home. The provision regulates the professional conduct of long-term care staff whose job it is to provide and support medical treatment and interpersonal care, and seeks to promote an environment conducive to such care. It is carefully calibrated to achieve these ends. It does not preclude facility staff from expressing their view about gender to anyone, including a resident, in any other lawful manner other than by misgendering a resident. And even then, the prohibition is limited to willful, repeated, knowing acts done because of protected characteristics for the moment. In this setting, and pursuant to relevant authority discussed below, governing public accommodation and anti-discrimination laws that prohibit acts that create hostile environments while only incidentally affecting speech, we conclude the First Amendment presents no obstacle. As we explain, the challenge provisions regulate speech only indirectly by prohibiting, analogous to Title 8 or 7, conduct that amounts to harassment or discrimination. In RAV versus St. Paul, great case, the Supreme Court considered the First Amendment challenge to a city's bias-motivated crime ordinance, which prohibited the display of a burning cross or other symbol that an individual knows or has reasonable grounds to know arouses anger, alarm, resentment in others on the basis of race, color, creed, or gender. The state Supreme Court had construed the statute to reach only fighting words and further concluded it was not overbroad and withstood strict scrutiny. The High Court reversed, confining. It is beginning to bother me a little bit. The Supreme Court keeps calling the Supreme Court of the United States the High Court. It just feels disrespectful. The High Court reversed, finding the statute was content-based regulation that failed strict scrutiny. Significantly for our purpose in doing so, the court articulated an important caveat. Laws regulating conduct may constitutionally prohibit discriminatory speech despite affording differential treatment to content-defined subclass of speech. The court explained that the First Amendment's prohibition against content discrimination is not absolute. The court analogized to Title VII's general prohibition against sexual discrimination in employment contexts as an example of a statute that permits targeted conduct rather than speech. Yeah, no one's talking about conduct. That's not the issue. The RIV court observed that sexually derogatory fighting words, among other words, may produce a violation of Title VII's prohibition, but fighting words are not constitutionally protected at all. So, there's that. In Aguilar versus Avis Renicar, a plurality of this court applied RAV in rejecting a First Amendment challenge similar to one plaintiff raises here. Pointing to a statement in RAV that harassing speech is sufficiently severe or pervasive to constitute employment discrimination is not constitutionally protected. The plurality upheld an injunction barring a manager who worked for Avis from continuing to violate the law by using certain derogatory racial or ethnic epithets to target the agency's Hispanic employees in the workplace. Our decision was announced in a plurality opinion by the chief judge and a separate opinion by someone else who concurred. The plurality opinion concluded that pervasive use of racial epithets has been judicially determined to violate the law as not protected by the First Amendment. In relevant part, the plurality drew upon ARAV and related high court law concerning Title VII employment discrimination, specifically hostile environmental context, all of which analyze anti-discrimination laws, permissible regulations of discriminatory conduct rather than protected speech, but it's just generally directed to speech. This one is specifically about words. That's kind of the... In light of these opinions, the plurality summarized the United States Supreme Court has held the use of racial epithet that is sufficiently severe or pervasive can constitute discrimination in violation of Title VII, and these decisions are at least implicitly inconsistent with any suggestion that speech of this nature is constitutionally protected. Indeed, the plurality held, these high court decisions made clear, the First Amendment permits imposition, but this, and also that's about words you can't use, not about words you must use, and that's a critical difference. That is a critical difference. So the Supreme Court has, from time to time, said, here are words you can't use. And incidentally, by the way, so is the common law, because these things are common law based, right? Defamation is not permitted, even if it's spoken. When it's spoken, we typically call it slander. So slander is spoken, but it's not protected. Fighting words aren't protected. Obscenity isn't protected. Right? So these are all things that prohibit you from what you can say. Right? You're not allowed to use certain words in certain contexts. But none of these decisions are about words you have to use. right? The decision from the Supreme Court concerning racial slurs was you can't use the racial slurs, not you must use other words. Then that's a critical difference in law that the Supreme Court of California is ignoring. Thank you, Tony P, for the 10 gift memberships. Is extensively appreciated. Accordingly, the plurality did not find First Amendment scrutiny to be appropriate. Rather, view the sole issue in the present case as where the First Amendment allows not only imposition of civil liability for past instances of pure speech that create the hostile work environment, but also the issuance of any injunction to prohibit continuation of such actions. I need to check something real fast. Actually, I need to check a couple things. One moment, please. Just had a thought cross my mind, and that's what I thought. Huh. Um, I need to cancel renewing subscription before I forget. Okay, how do I cancel this subscription? Here it is, cancel. Great. All right, that'll save me $100. Fantastic. Sorry for the break. Plural. I just subscribed also, by the way, for a year for the Juggernaut app for working out. So we'll see if that's a good idea. But it was $100 off because of Black Friday for the year. So, $230 for a workout app for a year, though, is not inexpensive. Although if you do that by month, it's actually not that bad. Because what is like 240 divided by 12? It would be like, it'd be 12, right? 12 times 12 is, no, 20. It'd be $20 a month. Yeah, so I guess that's okay. All right. So, all right. It's still a little expensive, but still a lot cheaper than a trainer. Anyways, pressing on. The plurality of Aguilar rejected the argument that the injunction constituted impermissible prior restraint on speech, reasoning that once a court has found specific pattern of speech is unlawful, an injunctive order prohibiting the repetition, perpetuation, or continuation of practice is not prohibited prior restraint. Because the injunction was based on continuing course of repetitive speech that's been judicially determined to violate the relevant law, the plurality held that prohibiting the defendant and its manager from continuing to violate the law does not violate their First Amendment rights. Finally, in addressing a claim that the injunction was overbroad because it applied even outside a hearing of plaintiffs, the plurality again analogized to Title VII's hostile work framework. Defendants argued that the use of racial slurs outside the hearing of Hispanic employment does not contribute to a hostile work environment if the audience does not find the speech unwelcome and the subjects of the racial invective are unaware they're being maligned. The plurality responded, although the incomplete record prevented outright ruling, it's possible use of racial slurs even outside the hearing of plaintiffs would contribute to an atmosphere of racial hostility that would perpetuate the hostile work environment. The concurring opinion, unlike the plurality, is subject to the injunction to the First Amendment scrutiny. In its view, the captive nature of employees in the workplace, paired with alternative avenues for voicing discriminatory beliefs, render the prohibition akin to a content-neutral regulation. The concurrence observed that strong public policies governing the workplace, both public and private, may justify some limitations on free speech rights of employees and employers, and stress the reality that the workplace and job sites are not usually thought of as marketplaces for testing of ideas. That's fair enough, right? I mean, they're not a traditional forum for exchange of ideas in this sense. The concurrence emphasized the injunction protected employees who were not reasonably free to walk away when confronted with racial slurs at work. It also found the employee's status as forced recipients of defendant's manager's speech lend support to the conclusion that restrictions on manager speech are constitutionally permissible in the circumstances at hand, where the regulation speech is limited solely to the workplace and the offended recipient continues to be a captive audience. Because of ample alternatives for advocating, espousing, or similarly stating discriminatory beliefs existed, the concurrence viewed the injunction as analogous to a permissible time, place, manner restriction on speech. But again, here critically, it's about words you must not say, not about words you must say. As shown above, anti-discriminatory laws like Title VII and FEHA permissively regulate discriminatory conduct and not generally be subject to First Amendment scrutiny, because the laws generally were about conduct writ large, and to the extent they were First Amendment, it's about words you couldn't say, not words you must say. For example, a prohibition on employment discrimination will require an employer take down a sign reading "white applicant only," but this hardly means the law should be analyzed as one that regulates the employer's speech rather than conduct. That's so because it's never been deemed an infringement of freedom of speech to make a course of conduct illegal merely because the conduct was in part initiated, evidenced, or carried out by means of language either spoken, written, or printed. Or otherwise, a law against treason could not restrict telling the enemy's national defense secrets. An ordinance against outdoor fires could not prohibit burning a flag, and antitrust laws would be helpless against agreements and restraint of trade. In other words, the High Court has clarified acts are not shielded from regulation merely because they express discriminatory idea or philosophy. Thus, like the plurality in Aguilar, we rejected the assertion that a law such as the one we considered here, aimed at discriminatory conduct, is subject to First Amendment scrutiny as an abridgment of freedom of speech. The relevant law targets discriminatory conduct by prohibiting acts that would create a hostile environment in long-term care facility, thereby facilitating the ability of such residents to obtain long-term medical and related intimate personal care in an environment that's conducive to and does not undermine such care. By contrast, the Court of Appeal below assumed the challenge statute triggered First Amendment analysis and indeed strict scrutiny because the prohibited conduct involves verbal communication. We disagree with the Court of Appeal's view. We acknowledge that the legislature's clarification of discriminatory conduct prohibited by a state's anti-discriminatory laws through enactment of a statute implicates spoken or written words prescribing certain willful and repeat acts of misgendering done on the basis of legally protected characteristics. Yet we interpret statutory provisions in context, not in isolation. So viewed, the challenge regulation is simply one aspect of overall legislative scheme directed at barring various forms of discriminatory conduct in the unique long-term facility setting. As further explained, the regulation's placement in a long list of provisions that limit specific actions in long-term care reveal the legislature's intent to address such related conduct by facility staff. The fact that one subpart of the statute can be violated by spoken words hardly means the law should be analyzed as one regulating speech rather than conduct. As established earlier, under a high court precedent, the regulation of discriminatory conduct does not trigger First Amendment scrutiny, even where the conduct is carried out through spoken or written expression. These authorities demonstrate that in appropriate circumstances, it's constitutionally permitted to prescribe acts that contribute to creation or perpetuation of a hostile work environment, even where those acts involve spoken or written communication. More specifically, for reasons outlined below, we conclude the Health and Safety Code, subdivision, prohibition, in the context of long-term care facilities, or willfully and repeatedly failing to use a resident's preferred name or pronouns after being clearly informed, constitutes proper regulation analogous to Title VII's prohibition of a hostile work environment. We need not analyze the boundaries of impermissible harassment and discrimination, because the challenge prohibition regulates conduct. Well, in part it does, but not the challenge provision. That's not conduct. That is, discriminatory actions taken wholly or partially on base of actual or perceived gender identity or expression. Corresponding to Title VII's prohibition hence reflects the sphere of conduct that high courts deem constitutionally prescribable. Indeed, the proscription at issue arises not merely from the workplace, but simultaneously in a special residential setting, where those whom the statute seems to protect are particularly unlikely to be able to avoid the conduct and particularly in danger of being harmed by it. All right, well, I'm going to go ahead and cut it off there because I think that basically covers the rationale of the decision. Then they're going to get into whether or not other aspects, but we've gotten to the speech aspects of it. And so we've gone to the core of the decision, the parts that I want to talk about. So I think we'll go ahead and cut it off there. But yeah, I mean, basically long story short, they're requiring healthcare workers and other workers in long-term care facilities to use preferred speech of people and not misgender people by using the preferred words. And if they can do this in the healthcare environment, there's no reason they can't. The legislature can't do this in the school environment or, daycare environment or other environments, especially where there's a captive audience, right? So, because, the people don't have the freedom to leave. And then they'll find out ways to do it in other environments too, I'm sure. So this decision will not stop here. It will be expanded. And, there's a pretty decent chance this case goes to the U.S. Supreme Court at some point, whether or not they're going to take this up today or some other time in some other version of it. But some version of this is going to the Supreme Court at some point of the United States. And it wouldn't completely surprise me if this one goes to the Supreme Court of the United States because, it's touching on a fairly important issue. And there probably is divide of legal authority on this. I mean, I haven't looked up other jurisdictions, but there's probably a circuit split on this. And even if there wasn't, this case involves particularly notable issues. So I think there's a real chance this gets taken up by the U.S. Supreme Court at some point, possibly this term even. They have time to dump it into this term if they really want to, although that would be a accelerated briefing schedule, but they could hypothetically do it. So we'll see. So I hope you enjoyed this read and learning a little bit more about California's stupid law. I think the key takeaway lesson here is stay away from California. They're kind of weird and they don't like you and your beliefs very much. So maybe just stay out of the state. It seems like a pretty good lesson to me. And that's what I'm going to do for the meantime. But until later, my friends, I've been on Civil Law. I hope all's well. Till later, my friends, cheers and goodbye.